most adult. Mic check 1 2. Testing 1.
Ladies and gentlemen, can I have your attention, please? Thank you so much. Welcome, everyone, to this very special, very happy occasion. We're here to celebrate our colleague and to learn from a scholar. The colleague, of course, is our very own Louise Weinberg. A few words are in order, although everyone gathered here, of course, knows Louise well. Louise is a pillar of the scholarly community, one who's improved and shaped our understanding of our Constitution, of our courts especially, for decades, our precedents too. Few have had the impact that she has had on the study of judicial power in particular. I'm thinking especially of her concept of judicial federalism. She's been a mainstay of our intellectual community here at UT ever since her arrival in 1980, and her presence remains strong, though she has moved to emeritus status. Her teaching impact was always large too, and here I think, and having been the Academic Affairs Associate Dean for a long time, well acquainted with this, her continuation of the beloved Supreme Court seminar as taught by our departed colleague Charles Allen Wright, And beyond our own confines here on the 40 acres, her impact on the larger Austin intellectual community, especially in concert with her beloved husband, the Nobel laureate, Steve Weinberg. That impact has been immeasurable for our city and the larger community too. So it was with great delight and very fitting that Louise and Steve created a wonderful and generous set of endowments to further enhance the intellectual life of our university and our school and other parts of the campus as well. And even better, that one aspect of that gift has resulted in the creation of the Louise Weinberg Chair in the Administration of Justice here at the law school. And another aspect of the gift has created the Louise Weinberg Lecture in the Administration of Justice, accompanied by the presentation of the Louise Weinberg Prize. Friends, I think a round of applause for our colleague Louise Weinberg, who's in the This is a distinguished award, and I'm very proud that our expert panel selected as the first recipient Professor Vicki Jackson of Harvard Law. Professor Jackson, as everyone here knows, is a renowned scholar of the Constitution, of courts, of comparative law. She's well known to us here at UT thanks to many wonderful scholarly presentations over the years right here in this building. But more important than that, she's well known to the entire intellectual community in law and legal institutions for her many works such as Constitutional Engagement in the Transnational Era, Constitutional Law in an Age of Proportionality, endless others. Now, I do know from our conversation, Vicki, last night at dinner, I'm particularly excited about your emerging line of work on knowledge institutions and the essential role that our various knowledge institutions, academic, media, and otherwise, play in a well-functioning constitutional democracy. And I was kind of hoping you could write extra fast on those projects because I think it's rather timely. But we delay you a bit from that project by asking you to be here today. As you all know, Professor Jackson is a titan in many fields. Her presence today honors us, and it well suits the occasion of the awarding of the first Louise Weinberg Prize. Professor Jackson, will you please join me over here briefly? Switch places. Okay. Professor Jackson, everyone.
Okay, thank you. Well, thank you very much, friends. It's so nice to be here again to talk with you on this occasion. I feel really very honored to receive this prize, and I'm so happy to be able to recognize the contributions of Louise Weinberg, a leading scholar in several fields, including federal courts and constitutional law. Professor Weinberg's insight and honesty in evaluating the court and her vision of the role of scholars in helping the court advance law and justice under the Constitution inspire my talk today, which is about state sovereign immunity from private lawsuits, a doctrine associated with the Constitution's 11th Amendment. Professor Weinberg has been a forceful critic of the court's decisions expanding 11th Amendment immunity from her influential 1977 paper on the new judicial federalism to her 2020 paper criticizing the court's untethered 11th Amendment jurisprudence and its, I quote, abnegation of the duty to place government at all levels under the rule of law. I hope to pay homage to her work today by considering the roles of judges and scholars in the evolution of our constitutional law of state immunity from suit. My talk has two parts. First, I will explain why two key Supreme Court decisions were wrong in ignoring the 11th Amendment's narrow, lawyerly text in the context of our basic constitutional commitments. Second, I will explore the court's difficulties in sustaining even moderately principled decision-making on states' amenability to suit on federal claims over the last 50 years. These difficulties not only damage the rule of law to the detriment of the just vindication of individual rights, but also undermine the court's status as a judicial form of principle. And I will echo Professor Weinberg's plea to scholars to continue to help the court find its way back to an improved understanding of this area of the law. Now, some scholars are now arguing that the 11th Amendment is distinct from an unwritten doctrine of sovereign immunity that came unannounced but hard-baked in the Constitution itself. This view is quite wrong. To see why, we need to go back to the Supreme Court's 1793 decision in Chisholm against Georgia. In that case, the court upheld its jurisdiction under, oh my goodness, I have to find my little pointer thingy, under Article 3's state diverse citizen head of jurisdiction, which is in red there, over a suit by a citizen of South Carolina against the state of Georgia on a contract. No federal question was raised, just a contract claim. 4 justices upheld jurisdiction, 1 did not. Each justice wrote separately. The majority opinions reflect a conception of the United States under the Constitution completely antithetical to a general constitutional immunity from suit. Thus, Chief Justice Jay, one of the authors of the Federalist Papers, explained that to imply an immunity from suit for the states would do violence, I'm quoting now, to the great and leading principles of a free and equal national government, one of the great objects of which is to ensure justice to all. It would, he said, be, quote, strange in the very Constitution by which the people profess to establish justice to so far deviate from the plain path of equality and impartiality to give the collective citizens of one state a right to sue individual citizens of another state and yet deny to those citizens a right of suing them. The state, for Chief Justice Jay, was a collection of citizens obligated to do justice, which the Constitution sought to establish. One more opinion by Justice Wilson, who was a member of the Committee of Detail at the Constitutional Convention. Observing that the Constitution does not use the word sovereign, he argued that just as individuals could be sued for wrongful acts, so too a state, a group of people, could be sued if it acted wrongly. He associated the, quote, haughty notion, close quote, of state sovereignty with, quote, despotic governments, and argued that particular clauses of the Constitution, including those prohibiting states from passing laws impairing contracts, plainly implied states' amenability to suit for their violation. Professor Jeff Powell has recently argued that the vision of Wilson and Jay in Chisholm, quote, deserves a central place, close quote, in our imagination of what U.S. constitutional law should be. Their analyses are wholly inconsistent with the idea that a broad common law system of sovereign immunity was rigidly encoded in the Constitution. But you may be thinking, the 11th Amendment was enacted in response to and in order to overcome Chisholm. Yes, true. But the 11th Amendment, which you can see on this slide, I hope, is not a full-throated assertion of a new principle. Rather, in precise lawyerly language, as you can see, it says the judicial power shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. Other proposals, some much more broadly, some more narrowly, were submitted but not enacted, from which scholars draw competing inferences. But as I hope you can see, the language of the amendment corresponds very closely to 2 diversity heads of jurisdiction in Article 3 at the bottom of this slide. Now, the narrowness of this language is inconsistent with a purpose to overturn such basic conceptions of the Constitution's goals as those of Chisholm's majority. The original Constitution, let's remember, was designed to strengthen the national government and secure supremacy of national law vis-a-vis the states. Its judicial power, including, oh, it's so amazing when this works, its judicial power, including over federal questions and admiralty law and ambassadors, was designed towards that goal of strengthening the national government. With this background, there are, I think, 2 possible ways to give meaning to the 11th Amendment's precise language. The first of these is that it was intended simply to repeal, I hope that's the repeal slide, from 2 heads of jurisdiction in Article 3, involving states and citizens of other states or of foreign states to repeal power under those provisions to hear suits against the states. Under this diversity repeal theory, other heads of jurisdiction, including admiralty and federal question jurisdiction, were left untouched. A second possibility consistent with text is that the amendment bars federal jurisdiction in any case against a state where the prohibited party configurations are present, regardless of the head of jurisdiction invoked. On this broad literalist theory, jurisdiction over federal question cases brought by out-of-staters would be prohibited, but not over suits by in-staters. All right, so I think I'm done with my slides. I'll leave that up for a little bit. As I mentioned, some folks are now arguing that there are actually two entirely different constitutional rules of state immunity to suit, each with a different source. The 11th Amendment, which prohibits all cases within the stated configuration regardless of state consent, and then an unwritten constitutional rule embodied in the pre-existing Constitution that bars jurisdiction in all privately initiated suits against state unless the state consents. Now, the idea that states cannot waive 11th Amendment protections is inconsistent with a great deal of case law. And the theory that there is a rigid constitutional sovereign immunity rule embodied in the original Constitution runs up against founding views like those of Wilson and Jay, as well as language in some early 11th Amendment case law that gave narrow readings to its force. The careful, lawyerly language of the amendment belies suggestions that it stood for or was consistent with a pre-existing general constitutional principle of state immunity from suit, silently incorporated in the original Constitution. I don't know how to turn this off, so I'm just going to leave it there. However, in 1890, in Hans against Louisiana, the court, having previously held that a federal question suit by an out-of-stater based on the Constitution was barred by the amendment, raised the paradoxical exclusion question. Why, the court asked, would the 11th Amendment bar actions by out-of-staters and not by in-staters against their own state? Now, under the diversity repeal theory, the premise of the paradox is rejected. The 11th Amendment did not bar actions by out-of-staters where jurisdiction was based on federal question. Let's see, I'll go back to that slide. It simply repealed the jurisdiction granted based on diversity of citizenship. Ignoring this possibility and the more cautious reading of the amendment in cases decided closer in time to when it was enacted, Hans held the 11th Amendment to stand for a principle of state sovereign immunity that would not allow the exercise of federal jurisdiction over a private person's federal law claim against a state without the state's specific consent. Soon after, this logic was extended to actions in admiralty and actions by foreign states, even though the amendment is conspicuously silent on those. But none of these cases involved congressionally authorized rights of action against states. Once Congress began legislating over economic matters in ways that intersected with the activities of states in running railroads, for example, questions arose first about Congress's power to regulate the states at all, and then about Congress's power to subject states to the same remedies as were authorized against private persons. On the first, the court unanimously held in 1936 that California was subject to a federal safety law when it operated a railroad, rejecting the state's suggestion that as a sovereign it was exempt. Scholars began to suggest that the 11th Amendment should be understood as directed at judicial implication of remedies against states under the common law, given its precise language that the power shall not be construed. And in a 1964 case called Pardon, the court upheld jurisdiction over a private suit under a federal statute against a state-owned railway. It reasoned that under Gibbons against Ogden, the commerce power was, quote, complete in itself, and that by operating in an area already regulated by Congress, the state had waived its immunity, a rationale that it would allow suits under federal law at least against states that chose to engage in an activity already subject to federal regulation. This constructive waiver theory differs from the diversity theory, but recognizes some congressional power to authorize private suits against states under Article 1, as would the diversity theory's view that states enjoy no constitutional immunity from federal question jurisdiction. Over the next period of time, the court did not extend pardon, but instead developed clear statement rules requiring that Congress speak with special clarity before its statutes were construed to subject states to private suits in the lower federal courts. Yet, the state courts were assumed by many to be available to hear federal statutory claims against the states. So, for example, in Atascadero State Hospital in 1985, Justice Powell, writing for the court, rejected arguments that federal law would go unenforced if the state could not be sued in federal court. He wrote, "The dissent argues that in the absence of jurisdiction in federal courts, states would be exempt from compliance with laws that bind every other legal actor in our nation. But," he said, "this claim wholly misconceives our federal system. The issue is not the general immunity of the states from private suit, but merely the susceptibility of the states to suit before federal tribunals. It denigrates," Powell said, "it denigrates the judges who serve on the state courts to suggest they will not enforce the supreme law of the land." In 1976, the court held that when Congress legislated under its 14th Amendment powers, it could abrogate state immunity from suit. In Fitzpatrick against Bitzer, it explained that the 11th Amendment and the principle of state sovereignty which it embodies are necessarily limited by the enforcement provisions of Section 5 of the 14th Amendment. But as to Congress's Article 1 powers, the case law was clouded. In 1987, in Welch against Texas Highway Department, the issue was whether states could be sued under the Federal Jones Act. 4 justices said even if Congress could abrogate immunity from suit under the Commerce Clause, it hadn't spoken clearly enough to do so. 4 other justices said Congress clearly has the power and has spoken clearly enough. Justice Scalia was in the middle. Noting that the parties had not raised whether to overrule Hans, he commented, "Both the correctness of Hans as an original matter and the feasibility, if it was wrong, of correcting it without distorting what we've done in tacit reliance on it are complex enough questions that I'm unwilling to address them in a case where the parties didn't raise it." He found that Congress had legislated on the assumption that Hans was the law and that he wouldn't read the federal act as applying to the states. But 2 years later, 1989, in the Union Gas case, the court held that Congress did have power to subject states to suit under the Commerce Clause, and that Congress had done so in the federal Superfund statute. Brennan wrote for a plurality, explaining that Congress could do so because, like the 14th Amendment, the Commerce Clause with one hand gives power to Congress, while with the other it takes power away from the states. The provision both expands federal power and contracts state power. That is the meaning, in fact, of a plenary grant of authority, and goes on to say there's no distinction between that and Section 5 of the 14th Amendment. So in consenting to the Commerce Clause, he says, states consented to both substantive and remedial legislation enacted thereunder. Brennan distinguished Hans on the ground that it involved no congressionally created cause of action. The decision thus interpreted Article 1 grants of power to Congress to carry with them a power to subject states to suit, an interpretation consistent with the diversity theory. Justice Stevens, agreeing with the court, characterized the sovereign immunity defense that he said the court had, quote, added to the text of the amendment in cases like Hans. He characterized that as a judicially created prudential doctrine, like abstention, that Congress could overcome. Union Gas's holding that Congress had constitutional power to subject states to private suits under the Commerce Clause lasted only 7 years. In Seminole Tribe against Florida, the court overruled Union Gas, holding that the background principle of state sovereign immunity embodied in the 11th Amendment means that even when Congress has complete lawmaking authority over a particular area, the 11th Amendment prevents congressional authorization of private suits by private parties against unconsenting states. For this court, there was a clear distinction between Article 1 and the 14th Amendment. It wrote, by expanding federal power at the expense of state autonomy, the 14th Amendment fundamentally altered the balance of state and federal powers struck by the Constitution. The rationale of Fitzpatrick and Bitzer was thus wholly inapplicable to the Interstate Commerce Clause because the 14th Amendment operated to alter the pre-existing balance of power achieved by Article III and the 11th Amendment. Congress's powers then under Article I were limited by the 11th Amendment, and Congress could not overcome that limit on the judicial power. So said Seminole Tribe. Now, Seminole Tribe, like Hans, was an error, but a more egregious one. At the time of Hans, the growth of federal regulatory legislation had barely begun, and there was no specific congressional decision to subject states to suit. Seminole Tribe was the most extreme form of judicial review in a democracy, one declaring a statute enacted by the national legislature invalid. This left a large hole in the Constitution's design for having a judicial power coextensive with the legislative, and it undermined state accountability and individual rights under federal law. Moreover, Seminole Tribe overruled Union Gas, which had better accorded with the precise language of the amendment. As Dean John Manning has argued, given the Chisholm opinions asserting that state sovereign immunity was flatly incompatible with the premises of our system, the amendment's carefully circumscribed language belies the presence of a broader constitutional immunity from suit. Seminole was just wrong. Part 2. But decisions since Seminole Tribe, I will now show, are littered with overrulings and inconsistency. Seminole Tribe's implications for state accountability were exacerbated by the extension of its reasoning 3 years later in Alden against Maine to hold that the powers delegated to Congress under Article I do not include the power to subject non-consenting states to private suits for damages in the state courts. This left Maine's public workers nominally covered by the Fair Labor Standards Act, but without the individual remedies in any court, state or federal, available to other workers, in Professor Weinberg's phrase, resulting in wage theft. The decision overturned the understandings of conservative and progressive judges in earlier cases that the state courts would be available to hear claims under federal statutes barred from the federal courts by the 11th Amendment, including a holding in 1991 that South Carolina was subject to private suit under a federal statute in its state courts. The directionality of Alden and Seminole Tribe was to weaken the role of individuals and courts to secure the rule of law, while increasing the relative power of the federal executive branch, which, under prevailing doctrine, was not barred from suing states. Alden grounded its sovereign immunity rule in the 10th Amendment, which, as Justice Souter's dissent noted, could have served as the basis for many past decisions without the embarrassment of ignoring the 11th Amendment's language. But, as Justice Souter saw it, there was, in his words, no evidence that the founding generation believed sovereign immunity was a general, constitutionally guaranteed immunity from suit under federal statutes, although it may have been a common law doctrine that could become part of a federal common law protection for the states subject to override by Congress, as some scholars, myself included, have argued. After Alden, moreover, the seeming clarity of the Seminole Tribe regime was placed in doubt. Seminole Tribe's majority had agreed with its dissenters that its holding would preclude congressionally authorized private actions against states under the Bankruptcy Clause and the Copyright Clause. But 10 years later, the court said, on careful reflection, it was mistaken. Central Virginia Community College against Katz upheld jurisdiction over actions against states to void preferential transfers, to get money back from the state in actions brought by trustees in bankruptcy. The court's reasoning failed to distinguish other Article I powers from that over bankruptcy with respect to suits against a state for money in the state's possession. The court argued, for example, that the framers intended to allow Congress to overcome a patchwork of state bankruptcy laws by establishing a uniform federal regime. But the Commerce Clause in particular was also motivated by concerns about the adverse effects of state laws and the need for federal regulation. Confusingly, the Katz court said it need not inquire whether Congress had clearly abrogated states' immunity because states had consented to bankruptcy suits in the plan of the convention, that is, in the Constitution's grant of the bankruptcy power. It thus dispensed with clear statement analysis. Perhaps this was all an effort to diminish apparent conflict with Seminole Tribe and accommodate Justice O'Connor, who joined the majority in both Seminole Tribe and Katz. All right, now Katz seemed to foreshadow an 11th Amendment doctrine that would go clause by clause. However, in the next major case in this line, the court treated Katz rather as an example of, I quote, bankruptcy exceptionalism, a good for one clause only exception to the rule of Seminole Tribe. You can hear Elena Kagan's voice in that. Allen against Cooper arose under a copyright statute in which Congress had clearly included the states in the parties that could be sued for infringement. The textual argument for an abrogation power was, I thought, stronger than in Katz, because while a law can be uniform for purposes of the bankruptcy clause, regardless of state immunity, the Copyright Clause authorizes Congress to secure to authors the, quote, exclusive right to their works. And without the power to subject states to remedies when they violate copyrights, it's hard to see how Congress is keeping the rights exclusive to authors. Nonetheless, Justice Kagan, writing for the court, relied on Seminole Tribe and its application soon later to patent and trademark cases as establishing the controlling rule for Article I powers with the sole exception of bankruptcy. Justices Breyer and Ginsburg, continuing to think Seminole Tribe was wrong, accepted that a majority of the court was now on board with Seminole Tribe, and they concurred in the judgment. So, after Allen against Cooper, for a teeny period of time, we federal courts teachers might have thought we had a relatively clear, albeit erroneous, rule of state sovereign immunity to causes of action under Article I statutes, except for bankruptcy. Any such clarity was made impossible, however, by the next two decisions. In 2021, Penn East Pipeline against New Jersey upheld Congress's power to authorize private parties to bring eminent domain proceedings against state-owned property under what the court called the eminent domain power of Congress. That power, the court said, is complete in itself. The idea first suggested in Katz that states had consented to suit in the Plan of Convention's bankruptcy clause was applied to say that the state had consented here. But in what clause? There is no eminent domain clause. I've looked repeatedly, it is just not there. The eminent domain power is necessarily carried out in executing an enumerated power, in that case, the Commerce Clause. It is simply ipsa dixit to characterize state consent to suit on this means of executing the commerce power as part of the plan of the convention. As Justice Barrett noted in dissent, I'm quoting her extensively, no one disputes that for 75 years after the founding, it was unsettled whether the federal government could even exercise eminent domain over private land within a state. Moreover, she said, it was then 77 more years before we held that the fact that land is owned by a state does not prevent its condemnation by the United States. Given the length of time these questions lingered, she continued, it strains credulity to say that history unequivocally establishes that states surrendered their immunity to private condemnation suits in the plan of the convention. Although the United States may sue states without regard to their sovereign immunity, allowing private parties authorized by federal law to condemn land and to sue states in condemning land was in real tension with at least two earlier cases. In 1991, in the Blatchford case, the court wrote, the consent inherent in the convention to suits by the United States under the control of responsible federal officers is not consent to suit to anyone whom the U.S. might select. And in Alden, the court emphasized the significant difference between suit by a private person, even when authorized by federal law, and suit by the United States, prosecuted, the court said, by those who are entrusted with the constitutional duty to take care that the laws be faithfully executed. In Penn East, though, the court simply announces that as part of a plan of the convention, the states agreed to suit in private condemnation action under federal law, without citing a shred of actual historical evidence from the founding that this was so, nor explaining why the eminent domain power is any more complete in itself than is the commerce power. The commerce power is described in precisely those terms in Gibbons and Ogden, a foundational case in U.S. constitutional law. And in Alden against Maine, the court had said that suits by the United States were sufficient to protect the supremacy of federal rights under the Fair Labor Standards Act. Why not so with respect to eminent domain? This goes completely unexplained. As Barrett's dissent continues, although Congress had previously authorized private parties to exercise eminent domain powers, the question here is not whether Congress can authorize a private party to exercise eminent domain rights against private parties. The question is whether Congress can authorize a private party to bring a condemnation suit against a state, and on that score, she said, the court cannot muster even a single decision involving a private condemnation suit against a state, let alone a decision holding that states lack immunity from such suits. Thus, the seemingly clear rule of Seminole Tribe had by 2021 developed two exceptions, one based on the text of the Bankruptcy Clause, the other a non-textual exception for a non-textual eminent domain power that was complete of itself. Penn East, like Katz, indicated that congressional abrogation is distinct from consent to suit in the plan of the convention. But in the context of suits under Article I statutes, is this more than wordplay? Amenability to suit will in either case depend on a federal statute that applies to the states. Finally, in Torres against Texas Public Safety Department, any possibility of Seminole Tribe providing a principled line disappears. Torres holds that Article I powers to raise and support the military allow Congress to subject states to suit by veterans there in the Veterans Reemployment Act. Texas's sovereign immunity objection was rejected. States implicitly gave up their sovereign immunity from congressionally authorized suits under the war powers in the plan of the convention, as with eminent domain in Penn East. The Constitution, wrote the court, provides a, quote, complete delegation of authority, end quote, empowering the federal government to provide for the common defense in several provisions and divesting states of similar authority. The court notes earlier cases upholding the federal draft and Tarbell's case rejecting state court power to order the release of federal soldiers. To illustrate the breadth of the power, Congress's power to build and maintain the military, the court says, is complete in itself, and states can't thwart it. In Torres, Justice Kagan joined the five-justice majority. She was the dispositive fifth vote, explaining that it was now clear that the court had not meant what it said in Cooper and Allen. She notes that although she had there described Katz's plan of the convention analysis as limited to bankruptcy, she thought there was a stronger argument for plan of the convention waiver of immunity with respect to the armed forces than with respect to eminent domain. I agree. But what about the Commerce Clause, Justice Kagan? It now seems that 11th Amendment issues are being subject to an unpredictable and historically ungrounded plan of the convention test, under which shifting majorities choose their favorite clauses under Article I, Section 8. Justice Breyer in Torres says the Commerce Clause might be distinguishable as not complete in itself because articles of commerce before they travel are subject to state regulation. This distinction is quite weak. I mean, human beings they're subject to federal regulation, and moreover, this explanation does not account for why, going back to Gibbons, the court described the commerce power itself as complete in itself. Justice Kagan's argument that the war powers are more complete in itself than eminent domain may be correct, but again, what about the Commerce Clause? Both the war powers and the Commerce Clause not only empower federal regulation, but of their own force displace state regulatory authority. All the dormant Commerce Clause cases are about that. The militia clauses of Article I, going back to defense, specifically reserve to the states the authority to appoint officers of state militias and to train those militias according to Congress's rules. Moreover, Article I, Section 10 says, no state shall, without the consent of Congress, engage in war unless actually invaded or in such imminent danger as will not admit of delay, meaning states can engage in war in those circumstances. And instead of an absolute prohibition, which the Constitution provides against states coining money or states entering treaties, you just can't do it, states may engage in war with Congress's consent, just as states may, with Congress's consent, regulate interstate commerce. Thus, how the war powers are distinct from those over interstate and foreign commerce remains, in my judgment, unexplained. Now, Justice Breyer offers a number of frameworks for how to think about this question. I'm happy to talk about it in Q&A. For now, I will say only that I don't think any of them is successful in reconciling this group of cases that I've been talking to you about. So, some concluding reflections. I'm almost done, less than five. Judges have to decide cases, and in reasonably timely fashion. Scholars don't have to decide anything. We can evaluate, we can critique, and sometimes some of us have the luxury of time to think about. As a scholar, I try to be sensitive to the role demands on judges when writing about their decisions, because having to decide is a different role than that of the scholar. Too much coherence in the law may not be possible without damage to other important constitutional values, so rough accommodations of competing values may result in lines of decisions that are hard to reconcile. But scholars owe courts and publics our intellectual honesty. Having read Professor Weinberg's critiques over time, I am drawn to her unwavering commitment to candor in the scholar's role, and from this perspective, there is only a little to praise in the court's 11th Amendment jurisprudence since Seminole Tribe. This would include the outcome in Torres, but there is much to condemn. Scholars, too, though, face a tension between the demands of finding coherence in a body of case law and advancing correct decisions under law. A tension that may be resolvable by helping the court develop plausible, even if not wholly convincing lines, limiting the most harmful effects of its past mistakes. For judges, the minimal requirements of rule of law, predictable and reasoned decisions are not being met in this area. Seminole Tribe overruled Union Gas and led to overruling pardon. Alden overruled prior understandings expressed in many cases about state court suits. Katz departed from Seminole Tribe. Allen against Cooper in 2020 limited Katz to bankruptcy, but more recent decisions undo that limitation. There is no substantial basis suggested in either Penn East or Torres to distinguish those powers of eminent domain and war from federal power over interstate commerce with respect to state sovereign immunity. And justices from whom we might have expected efforts at reconciliation have not provided them. In Penn East, for example, why did Chief Justice Roberts write for and Justices Alito and Kavanaugh join the majority, given their agreement with Allen against Cooper? The only reference to Allen in the opinion refers to a distinction between abrogation and waiver of immunity in the plan of the convention. But why no plan of convention waiver for the copyright clause? I think we're entitled to expect more reasoned decisions from our judges. What's the way forward? We need from scholars meaningful readings of the 11th Amendment that would improve on the current disarray without unsettling huge swathes of law. There are compelling structural and historic reasons to view federal question jurisdiction as unaffected by an absolute constitutional immunity for states from private suits, even if a federal common law of state sovereign immunity is recognized. The diversity theory would support such a view and has considerable scholarly support. Rigid sovereign immunity bars are inconsistent with Marbury's principle that the essence of civil liberty is that the law provide a remedy for the violation of legal rights, and state sovereign immunity is also inconsistent with the founding idea that the judicial power should be coextensive with the legislative. The most legitimate concern, I think, behind the expansion of state immunity is the potential existential threat to states as governments that could result from massive liabilities. The risks that these could arise from federal statutes, however, can be contained at least in part by Congress providing special rules for actions against states as exist in some statutes. Moreover, as both Professor Weinberg and I have argued, state sovereign immunity is best understood as a form of federal common law. Existential risks to the states can be contained through remedial principles developed under federal common law, for example, limiting or excluding awards of punitive damages, and by careful review of other forms of relief to evaluate more particular threats to states' existence as constitutional governments. But it is inconsistent with our Constitution's commitment to establish justice for a principle of unaccountability for legal wrongs to play so powerful a role in our jurisprudence. In Professor Weinberg's words, it is both intellectually unfounded and unjust, and I would say a threat to the rule of law as well as the supremacy of federal law. Scholars and the court need to work to retrench the scope of that unaccountability. And I'm done. Thank you.
Sitting next to Jay, we all know that bankruptcy is special, but
quite striking that the 11th Amendment refers specifically to suits in law or equity.
And not to admiralty.
And no mention of admiralty, which is the tradition, which is the third member of that tripartite array there. Has there, I should already know this, but you know, aside from Welch, what is there on the admiralty side?
So in a case, I'm going to get the name wrong, but New York was one of the parties in the first third of the 20th century. Am I right on that, Tara? Yeah. In the first third of the 20th century, the court says, oh, postulates that control behind the 11th Amendment mean a jurisdiction can't be exercised in admiralty, even though the word isn't there and law and equity are there. It's ipsa dixit. And the court has allowed federal courts to make decisions in admiralty that affect state interests in property as long as the property is not in the possession of the state. That is, it's in somebody else's possession and there's a contest over who owns it. That, the court has said, does not offend the 11th Amendment. But the Katz case suggests that the importance of whether the property or money is with the state or not with the state doesn't matter, at least on the bankruptcy side. So I'm not going to try and reconcile that, but that's.
There is an early 20th century case, Workman versus New York, that says that New York cannot apply a, I can't remember what the exact detail was, but it was something like a limitation on damages.
So that has to do with the conflicts of substantive law of admiralty, federal and state. And so one of the crazy things about the 11th Amendment is that it bars suit against states in areas where federal law is valid and concededly controls as a matter of substance. It is bizarre, I think, and it's that bizarreness is one of the structural reasons that I and some others think the diversity repeal theory makes much better sense of the text.
So thank you so much. This was wonderful, especially for a federal court nerd. I'm just so happy right now. And just such a wonderful tribute to Louise. So thank you. Constitutional interpretive question and then a stare decisis question. It seems to me that the fight over the 11th Amendment is really a war between textualism and originalism. And this is not a war people talk about very much because they often treat a textualist as an originalist, but it seems to me that we've got maybe bad originalism, the history that people are coming up with, but it really seems to be a war there, and I'm curious if you agree. On stare decisis, so you didn't say we should overrule Seminole Tribe, but I feel like you were kind of saying we should overrule Seminole Tribe, and of course many justices have said that over the years, and one of the things that I think many of us struggle with as we look at the Supreme Court's attitude towards stare decisis over the past few years is how do we figure out which decisions really do justify overruling without undercutting the entire regime of stare decisis in the Supreme Court?
All right, so those are great questions, and I'm not sure I have, I'm sure I don't have great answers, but I will say something. So on the conflict you see between textualism and originalism, I think yes, to a certain extent. Of course, the text might be taken to actually be the best indicator of original understandings. So I'm not sure I want to accept the kind of opposition that is posited. Sometimes in the later opinions, justices will write things like, well, if someone had said that you'd be able to sue the states on this or that, that would never have gone forward. Now, you know, historical imagination backward, maybe that's right, but who could have imagined in 1791 or 1793 that a federal law would validly regulate wages and hours? And not just of people working on railroads, but of people working in factories. So I think that the kind of I think that you can find evidence by important actors in the founding period that suggests that people assume sovereign immunity will bar relief. You can find statements by important actors from the founding period, including the two justices who I quote on the court that say, actually, no, it's contrary to the basic principles on which we're constructed. So, fog. Now, when you have, so that's kind of what I think about the tension, is that it is there in part. It is there particularly in the asking of the sort of counterfactual hypotheticals that good historians know you just cannot answer because you're working in a different period of time. On stare decisis, so I care about stare decisis, and I am not sure what I want to say about that, but I think what I want to say is that stare decisis, if Seminole Tribe hadn't had cats, if it hadn't had Penn East, I think I would not be inclined to say it should be overruled. I would say it should not be extended. You should not be treating injunctive relief actions as raising sovereign immunity issues, as was done with respect to state court judges in the whole women's health case. But the court itself has not accorded stare decisis effect to Seminole Tribe's reasoning. It is not true under the court's case law that Congress lacks power under Article I to overcome the 11th Amendment's prohibitions on suits against states. So the court itself has already very substantially weakened the stare decisis character of Seminole Tribe, and that weakening began in the Katz case, which was 2006. Thank you. So I didn't make a full-throated argument on it because, it's troubling. Some degree of continuity in law is important, even if the rule isn't a great one. But Ernest Young, who I think is a very good scholar, has a good piece on where the 11th Amendment is now. And I don't, and what he says is, well, it's all messed up, but it's not such a big deal because we have other doctrines available to try and keep governments under control. And I'm less sanguine than he is about that. And I think that the conflict between what I think are constitutional fundamentals about individual rights, about justice, about the role of courts, and about the supremacy of federal law are all inconsistent with Seminole Tribe. So might I get to the place in a year or so where I'm writing about overruling Seminole? I might, but I haven't quite gotten there for purpose. I thought I put enough on the table for you folks to chew on.
I've been sitting here debating whether or not to pull myself out of the queue because Tara got to my question before I did, which was about, I heard you express equivocation about whether, the job is to reconcile these, potentially inconsistent cases or to get behind, and the tension that presents with like propping up, a case that makes no sense. I wonder though if you could talk a little bit about what it feels like, and tell me if I'm wrong. It feels like Seminole Tribe is what we might call a fixed point for conservative legal theorists. In other words, it's just something that it feels like they have to accommodate, because I have a difficult time understanding how conservative legal theorists with the methodological approaches that they generally embrace today gets to the result in Seminole Tribe. Nevertheless, right, it seems like they're unwilling to back that down. Like, what's the evidence for that in Seminole Tribe? Well, there's this, in addition to many other things, right, there's this really nasty slight at legal academics.
Oh yeah, cobbled together from law reviews.
Were you part of that?
Yeah, because
Yeah, it's just really, no, but it's really reads like a rallying cry against like sort of like dismissing us, right, as not mattering. And I think that type of language is something that is indicative of what I'm calling a fixed point for, a conservative legal approaches. I see Tara shaking her head, so
no, this is Lee. This is great. I don't mean to cut you off, but I'm
No, no.
very happy. So earlier drafts of this, before I practiced and found out they were too long, had two paragraphs on the cobbled together point, because it seems to me that both the justices and scholars in federal courts, well, that for some scholars and for all of the justices, there ought to be a sense that we're in a collaborative enterprise, that we, the scholars, are trying to help the court get to the right thing. Those of us, now, I'm not saying you have to do that as a scholar, okay? You can be, very, very critical, throw the whole system out. I'm not trying to suppress scholarship, but those who work in the kinds of spaces that I have worked in this, are trying to help. And for the court, and the court, doesn't have money, doesn't have arms. It ought to be wanting to be engaged with legal communities that are interested in its work, like scholars. And so I had a couple of paragraphs about why there should be a more collaborative kind of attitude displayed by people on the court. Now, in recent cases, I think Justice Gorsuch has been citing Will Bowden and my colleague Stephen Sachs's work, which I think is very good work, and I completely disagree with it. So it's not, but is it a fixed point? I don't know. I mean, John Manning is a real textualist, and on many issues, he is more conservative than liberal. And his piece, which is written after Seminole Tribe, is very measured, very even-handed, says I can see how people could argue that there is a big immunity that was there all the time, but he says, I just don't think it's credible given the background against which this 11th Amendment text was enacted. If you didn't have Jay and Wilson saying, the Constitution is about equal justice and let everybody come in and get sued, then maybe you could say, well, in addition to this narrow text, there was a pre-existing immunity. But he says the fact that they chose to write so narrowly really makes it very hard to sustain that position. So I'm hoping that the world is not as monolithic as that. I will say one other thing on the stare decisis point, which is, so I wrote a very, very long, I look back, it's like 130 pages article in 1988 on the 11th Amendment. And it was obviously before Seminole Tribe. The Welch case, where Justice Scalia was in the middle, had been decided, but the issue of Article I abrogation was up for grabs. It was before Union Gas. And I talked about stare decisis then, and I went through, Powell wrote in Welch, said, if we were to hold that Congress could subject states to suit under Article I statutes, we would be overruling 17 cases, and he lists them. So I went through the 17 cases, and it turned out the number that would actually be overruled was very, very small, because most of them rested on other grounds. I care about that. Have I done that exercise with respect to overruling Seminole Tribe? I haven't. So I've given you some reasons why I think the stare decisis claims of that case are not so strong, but I haven't done the kind of complete analysis that I think a good scholar would want to do, who cared about stare decisis would want to do before fully coming down on it. But thank you for the question.
Time for a final question from Jordan.
Hey, Vicki, this is wonderful. It's very hard to disagree that the 11th Amendment jurisprudence is a mess, or that it's atextual, ahistorical, distorts the role of courts in enforcement of rights. I'm surprised you didn't talk a little bit more about what I think of as almost the worst collateral damage, which is, given Seminole Tribe, it puts a lot of pressure on Congress's power under Section 5 and the Reconstruction power. And it strikes me that the worst part of Seminole Tribe is that it actually has led the court into this effort to eliminate Congress in its role in protecting fundamental rights, and that the whole Bernie line of cases has actually wrought as much damage as the 11th Amendment cases in Article I, in terms of limiting what Congress can do to enforce Section 1.
So I completely agree with your distress at the court's lack of respect for Congress. I agree with you on the adverse effects of City of Bernie against Flores as it has developed in the case law. I'm not commenting on that case, but as it has developed in the case law. I agree with you that the effect of Seminole Tribe was to create what I call the bifurcated Constitution. in which there was a lot of pressure being placed on Section 5 powers to try and get justice, which the court has persistently blocked through reasoning that is very expansive in narrowing the space of what will count as a Section 1 violation. So just to give folks in the room an example, there was an effort to uphold suits against states under patent and trademark law in 1999, and the court said it's not enough. It doesn't constitute a denial of due process, even though patent is a property right. It's not a denial of due process if, when the state is sued, it asserts sovereign immunity and blocks the court. It's not? The court seemed to suggest that the states would have to do this over and over again and not provide any possibility of relief through administrative agencies or legislatures or anything. Well, guess what, folks? Jurisdiction over patent claims has been exclusive in the federal courts for years. So, narrowing, in line with what we saw in City of Bernie and Shelby County against Steele. I think that is, yes, I think the 11th Amendment case law has contributed to that trend. I thought you were going in another direction because another adverse effect of the 11th Amendment case law, in addition to what Jordan has absolutely properly brought up, is the way it intersects with the court's contraction of the role of remedies against individual officers in vindicating public law. So if you go back to the founding period, you have these astonishing cases. Little and Bareem is my favorite one, where a sea captain is following the president's orders to interdict a ship that's going from France to the US. Turns out the statute only authorized interdiction the other way. I may have the directions wrong, but only authorized interdiction the other way. And the captain says, yeah, but I was following the president's orders. And the court says, gee, we really feel for you, but you violated the rights, you're liable. Okay, completely different universe now, where even when a police officer violates the Fourth Amendment, in dealing with someone, unless the violation was extremely clearly established by existing law, no relief. This is not the world of Marbury's How Do You Keep the Essence of Civil Liberty Going. So that there are many pieces of this. The problem is, I mean, it's complicated enough that it takes a while to lay out, or at least that was my judgment. And I, at one point, had thought of trying to include 14th Amendment and just thought it was beyond me in the time that the dean had generously allotted to me.
Well, what better note to finish on?